Namaskaram, Vanakkam, Sat Shri Akal. Oops, sounds like Bhaijan. Just to clarify, I'm yet to see the popcorn punishment, so please don't jump into judging me. Let's start again. Hello, my dear innocent aspirants and Constitution fans. If you thought Indian democracy was not spicy enough, wait till you hear this legally tandoori drama between the Tamil Nadu government and, of course, the governor, Mr. R.N. Ravi, featuring delayed files, ghosted bills, and an Article 200 showdown, which finally ended in the Supreme Court's mic drop moment. The judgment today, the state of Tamil Nadu versus Governor of Tamil Nadu 2025. Now let's rewind to 2020. What's the case all about? See, the Tamil Nadu Legislative Assembly had been passing some bills. Nothing wild, nothing revolutionary, just things like changing how the vice chancellors are being appointed in the state universities, adding the finance secretary's name to the university syndicates, starting also a state Ayurveda university, giving the state government the power to inspect universities instead of the governor doing it in his role as a chancellor. I mean, it sounds reasonable, right? But the governor apparently did not think so. He did not assent to those bills. He did not return those bills. He was just sitting on them. And in total, between January 2020 to April 2023, there were around 12 such bills pending on various topics. And to add to it, you had all these files which were seeking the prosecution of public servants under the Prevention of Corruption Act 1988. And also, there were more than 50 files on the premature release of prisoners, which were stuck between August 2022 till, of course, June 2023. In fact, not just this, there were some proposals pending for the appointment of members in the Tamil Nadu Public Service Commission as well, completely ignored. So basically, if you submitted paperwork to Raj Bhavan, you might as well have sent it to the Hogwarts. So Tamil Nadu had enough finally, and in October 2023, the Tamil Nadu government went to Supreme Court. And finally, the judgment came today, where Supreme Court responded very clearly in a two-judge bench judgment starring J.B. Padiwala and Justice Madhavan. The governor's delay has been deemed to be now illegal. Secondly, sending bills to president after they were reenacted or passed again, that's also unconstitutional. And Supreme Court, interestingly, has used Article 142, the source of judicial activism, to do what? To give assent to the bills. The Supreme Court has said that all those pending bills are now approved. The bills are deemed assented to. Beautiful use of Article 142, now entering the domain of the executive as well. Anyway, beyond this, the Supreme Court has also given some real timelines because, Raj Bhavan apparently needs some kind of reminder that democracy runs on clock, not just vibes. Anyway, before moving on to those guidelines, let me just recap what is the current situation under Article 200. So, under Article 200, whenever the state legislative assembly or the state legislature passes a bill to the governor, he or she can reject the bill, can take no action because there is no time frame mentioned, and can also send the bill back to the state legislature for reconsideration, which you refer to as what kind of veto? This is what is known as the suspensive veto, right? And also drawing inspiration from the Canadian Constitution, Section 55, we have something called referential veto, where the governor can also reserve the bill for the consideration of the big boss, the president. Now, since there is no time frame mentioned, we assume that the governor is supreme using the pocket veto. However, Supreme Court has now set mandated deadlines. So what are the deadlines? Number one, whenever, say in case of withholding assent and reserving it for the president with the aid and advice of Council of Ministers is concerned, the governor must take a decision with a period of maximum 1 month. Meaning, when a bill is passed by the state legislature and comes to the governor, and the governor has been told, the governor has been informed by the state government to give assent, or maybe the state government is okay vis-a-vis the governor referring it to the president, then within 1 month the governor must take some action. Now, if the state legislature passes the bill to the governor and the governor does not like this bill, if he say in disagreement with the advice, in case withholding of bill or referring to the president is against the advice of the state government, then the governor must decide within 3 months. So this is the maximum limit. In short, whenever the governor receives a bill, he can either take action of what? Referring it to the big boss president, or using suspensive veto. Within how many months? Just 3 months. Within 3 months, you will have to take a decision. So there is no unlimited, unfettered, unrestricted pocket veto from now. And once a bill has been sent back to the state legislature, that suspensive veto, the legislature passes the bill again. In this situation, if a bill is repassed, then the governor must take action in how many months? Just 1 month. So in any case, the governors can now no longer delay the passage of bills by more than 4 months. 3 in this case, plus 1 maximum in this case. These are the new guidelines. And of course, finally, the mic drop message from the court. The governor must not be a bottleneck. He must not reduce the constitution to a waiting room. He is not a monarch. He is not a political agent. A very beautiful statement that the governor is not some political agent, right? He is a constitutional authority and he should act like one. And yes, Supreme Court has also said there is nothing called a pocket veto. No such thing as a pocket veto exists in the Indian Constitution. This is an American thing, not an Indian thing. So, dear viewers, next time a governor delays a bill and keeps the state government waiting, like the online order you were waiting to receive from that fake website where you placed the order way back in 2023, please remember this case, the state of Tamil Nadu versus the ghosting and gaslighting by the governor of Tamil Nadu. And the Supreme Court saying loud and clear, governors are not the final editors of democracy. So don't forget to update your notes and maybe tag your governor. Maybe it will get him to respond faster than his file movement. And before we end our short video, let's remind ourselves as Dr. B.R. Ambedkar warned us. However good a constitution may be, if those who are called to work it happen to be bad lot, the constitution will prove to be bad. That's all for this video. Jai Samvidhan. Jai Hind.